I'm joined by my colleague, Stacy Oshima from the UC Irvine Career Center, who will be moderating the Q&A. And we also have our special guest speaker today, Mark Rhoads. This webinar is part of the first annual University of California Career Conference for international students. And this event was made possible by the joint efforts of the career centers across the University of California. So I want to give a very special thank you to all of the participating campuses. I'll give a shout out to UCLA, UC Berkeley, UC Santa Barbara, UC Santa Cruz, UC Irvine, UC Riverside, and UC San Diego. Just a note, we are recording this webinar and the video will be made available to those who registered for the session. You'll receive an email in the coming days with a link to access it. If you have any questions during the presentation, please drop those into the Q&A. We'll get to your questions at the end. We'll have about 15 minutes or so for Q&A from the audience. Now I have the pleasure of introducing our guest speaker today. Mark Rhoads is an immigration attorney in the Immigration Practice Group of the law firm of McCandlish Fulton. Mark has over 28 years of immigration law experience, working with companies all over the United States, processing work visas and permanent resident green cards for international employees. He has successfully prepared countless work visa petitions, including thousands of H-1bs, as well as green card petitions in all categories. He regularly speaks on immigration law topics to university groups and business audiences across the United States. And Mark is a member of the American Immigration Lawyers Association and is listed in Best Lawyers in America in Immigration Law. Welcome, Mark. Thank you so much for being here, and I'll turn it over to you.
Okay, thanks very much. Well, as Karen said, my name is Mark Rhoads, and I am an immigration attorney. What that means is that what I do for a living is that I work with companies all over the United States, processing work visas and processing permanent resident green cards. Over the course of the next 45 minutes, what I'm going to try to do is to give you a fair amount of information about how the immigration process works in the United States, and that is you as an international student in F1 or J1 status, how do you move from being an international student to getting a work visa and staying in the United States? Out of my office, we process thousands of work visas and green cards every year. And I can tell you that when you are out in the job market and you are talking to employers about job opportunities, one of the first questions they're going to ask is, well, okay, you're an international student. What kind of work visa can you get to stay in the United States? Because I just from my experience, many employers, many companies in the United States have no idea how the immigration process works. So it's very important for you as an international student to understand how this process works so that you can explain it to the employer in simple terms to help the employer understand it so that they are comfortable proceeding to hire you and then sponsor you for a work visa or a green card. And just I have my contact information up on the screen. I have some kind of anti-Zoom force field that somehow screens freeze up or my audio goes off or something goes wrong during the course of these presentations. Or even if I just don't get to your particular issue, if you have questions that are not answered during the course of this session, please feel free to give me a call or send me an email. I answer questions from international students all over the United States regularly. I don't charge for those kinds of quick email or phone consults. So I encourage you to keep my information handy. So let's jump into how this process works. There are many, many work visa categories in the United States. There are work visas that run from the letter A all the way down to the letter V as in Victor. And every one of those letters has a visa category associated with it. But I can tell you that in practicing immigration law for over 25 years and dealing with tens of thousands of international students over that time, what I have put up here on the screen is the path that about 95% of every international student will follow in order to stay and work in the United States. And that path is this. If you are an F1 student, When you graduate, you'll get something called optional practical training, OPT. You'll get optional practical training for 12 months, or if you're in a STEM degree program, you can get optional practical training for an additional 24 months for a total of 36. OPT, optional practical training, is the easiest way to get your foot in the door with an employer. It allows you to work for any employer anywhere in the United States, as long as the job is related to your degree program. And I'm going to talk in a minute about how to take advantage of optional practical training. So step one, if you are F1, is to get optional practical training. If you're a J1 student, you'll get something called academic training, slightly different than optional practical training, but that allows you as a J1 graduate to stay and work in the United States for 18 months, or if you're a postdoc, up to 36 months in the United States. Whether you are F1 using optional practical training or J1 using academic training, while you are using your practical training, you will want to talk to the employer about filing for an H-1b. H-1b is the most common work visa in the United States. It will allow you to stay and work in the US for up to 6 additional years. So step one is optional practical training or academic training for Js. Step two is to get the H-1b. H-1b, as I said, allows you to work for up to 6 years in the United States. While you're working using that H-1b for that 6 years of work eligibility, it's during that process that most international workers in the United States will process a permanent resident green card. You don't necessarily have to go in that order, but as I said, about 95% of every international student that I have ever dealt with goes exactly in this order, following this path. Optional practical training or academic training, then the H-1b, then a permanent resident green card. And I'm going to hopefully have a little bit of time towards the end of the program to talk about how to get a permanent resident green card. But let's look at the first 2 steps first, because that's the way that you're going to stay and begin to work after graduation. Step number 1, optional practical training. If you are an F1 student, and because the vast majority of folks in the audience are going to be F1, I'm going to focus on that. If you are a J1 student and have questions about J1 academic training, I encourage you to talk to your foreign student advisor at your university. Focusing on the F1 and optional practical training, as I said, optional practical training is available to every F1 student after graduation, and it will allow up to 12 months of work authorization after you graduate. In order to take advantage of optional practical training, you first have to get a card. It's called an Employment Authorization Document, an EAD, that is a work card that looks almost exactly like a little driver's license. And in order to take advantage of optional practical training, you must get that work card. You cannot start to work using OPT until you have the card. If you start to work for an employer before you have the card, you are deportable from the United States. If an employer puts you to work before you have that card, that employer can be fined by the federal government. No employer wants to take that chance. So in order to take advantage of optional practical training, the first step to staying and working after graduation is to get that Employment Authorization Document, the EAD. So how do you get that EAD? I encourage all of you, I guarantee that at your universities, they have programs on applying for your optional practical training after graduation. Attend those programs. If they have webinars, attend the webinars. There are a lot of different rules related to applying for that EAD, and it's very important that you comply with those rules. If you fail to comply with the rules for applying, you will lose your ability to get that EAD. You will lose your ability to take advantage of optional practical training, and in all likelihood, you will lose your ability to stay and work in the United States after you graduate. So I encourage you to work closely with your foreign student office to make sure that you take advantage of optional practical training. But let me give you a couple of issues that I see time and again in my law practice that come up year after year. Question number 1, when can I apply for this work card? Well, there is a window to apply for the card. And that window is you can apply for the card up to 90 days before graduation. or up to 60 days after graduation. So that's the window to apply. What I usually recommend is go back to your dorm or to your apartment, find your graduation date, circle it on a calendar, count back 90 days. That's the first day that you can apply. There's no reason to delay. You could apply anytime within that window, anytime 90 days before graduation or up to 60 days after, but you can't work until you have the card. And right now it's taken the Immigration Service well over 4 to 5 months to process one of those work cards. So the earlier you apply, the more likely you will have that card in your hand soon after graduation and you can go to work. Now, once you apply for the card, you're allowed to remain in the United States until that card is issued. When the card is issued, it will have an effective date on the card. Starting on that effective date, you can go to work for an employer. So apply early. There is no reason to delay. The longer you delay in applying, the longer the delay before you get the card and you are able to go to work. Now, once you get that card, here is a very important issue, and that is once the card is effective, you only have 90 days of unemployment time permitted. So once the card is in your hand, you don't have to have a job offer to apply for this card. You don't even have to have started looking for a job yet. As long as you're an F1 student and you're graduating and you're in your final semester and you're within 90 days of graduation, you're automatically allowed to apply for the card. But once you get that card, you only have 90 days of unemployment time. What that means is that once the card is effective, you need to hustle to find yourself employment that is related to your degree program. You are permitted in using optional practical training to start your own business. There are many international students that start their own business. There is an issue with that when you move to H-1b later on. And if you have questions about starting your own business, I encourage you to send me an email or give me a call. I'm happy to talk to you about it. But that is one way to stop the unemployment clock. If you're unable to find employment elsewhere, is to start your own business as long as what the work that you're doing is related to your degree program. I get questions from students all the time about whether they can actually volunteer work for free in order to stop the unemployment clock. And the answer to that is the Immigration Service has indicated that volunteer work is permissible to stop the unemployment, the 90-day unemployment clock, but that volunteer employment must comply with labor laws. In general, the labor laws in the United States do not allow volunteer work, but there are circumstances where volunteer work can be an effective way to stop the unemployment clock. While you're working using your optional practical training, so let's say you've listened to what's gone on here, you're within your final semester of your degree program, you apply for your optional practical training work card. That card will come in the mail to you. It'll have the effective date. You find an employer, you go to work for that employer. You can work using that card for up to 12 months. If you are in a STEM degree program, you can actually apply to get an additional 24 months of optional practical training. Not every student in a STEM degree program will qualify for this additional 24 months. In order to qualify for the additional 24-month STEM extension, you must be working for an employer that is enrolled in the E-Verify program. That is, E-Verify is a program that the government has implemented that requires enrolled employers to submit documentation to the government about their workforce to demonstrate that the employees are all legally authorized to work in the United States. Not every employer is enrolled in E-Verify. If you are a STEM graduate and you are working using your first 12 months of OPT, in order to apply for that additional 24 months, you must be working for an employer enrolled in E-Verify. I get students ask me frequently, how do I know if the employer is enrolled in E-Verify? The answer to that is ask them. Every employer enrolled in E-Verify is going to know whether they're enrolled. If you're working for an employer that is not enrolled, the employer can enroll in E-Verify at any time, even after you started working for them. That would qualify you to apply for the additional 24 months of optional practical training. but it's very important that the employer must be enrolled in E-Verify. If you are working using the STEM extension of your optional practical training, again, you have an unemployment clock. That unemployment clock is actually extended to a total of 150 days of unemployment time. If you're working for an employer and the employer terminates your employment, that unemployment clock will begin to tick. Does this give you an ability to own your own business? The answer to that is you can start your own business in the first 12 months. But in my view, you could not continue to work in your own business during the STEM extension of your optional practical training. And the reason for that is that in the STEM extension, the employer that you're working for must prepare and submit a training plan to the federal government. This training plan is a form you have to fill out to show that the work that you're doing actually provides you with practical training related to your degree program, and you have to be supervised in connection with this training plan. If you own your own business, the Immigration Service is never going to agree that you're supervising yourself. So in my view, you can start your own business in the initial 12 months of OPT, but you could not continue that work in the STEM extension unless there are other people involved in the business at that point who would be supervising your practical training. So optional practical training, again, is the best way to get your foot in the door with an employer. You have that work card. It allows you to go to work for any employer doing any job. The employer doesn't have to do anything. They don't have to file paperwork with the government for you to get that optional practical training. They don't have to pay fees. All they have to do is decide that they want to hire you. You can go to work using OPT. So that is step one to working in the United States after graduation. While you're working using your optional practical training, whether it's for the first 12 months or whether it's for the additional 24-month STEM extension, you know that there's a clock ticking, and at the end of your optional practical training, you are either going to have to depart the United States, and you'll have 60 days to depart the US at the end of your OPT, or you can try to extend your stay in the United States by filing for an H-1b visa. H-1b is the most common work visa in the United States. So let's talk about how the H-1b process works. When you're working for your employer using your OPT, you're going to want to go to that employer and say, hey, employer, I'm great. You like my work. I have this optional practical training work card, but the time limit is limited. And at the end of the expiration of my optional practical training, I'm either going to have to leave or we're going to have to get a longer term work visa. The longer term work visa is the H-1b. There are 3 requirements to getting an H-1b. Requirement number 1, you must have an employer. Only an employer can file an H-1b petition. You cannot file an H-1b petition on your own. If you think back to optional practical training, you applied for that work card. You didn't even have to have an employer when you applied for your OPT. H-1b is very different. You must have an employer. Only an employer can file an H-1b petition. Requirement number 2, you must have a degree. You cannot file for an H-1b until you have a degree. That is either a U.S. bachelor's degree or higher, or a foreign degree that is the equivalent of a U.S. bachelor's degree or higher. So if you are currently in a bachelor's degree program, you cannot file for H-1b until you have a degree. If you are in an advanced degree program, that is a master's, a PhD, a JD for lawyers, whatever, if you are in an advanced degree program, you already have a degree. So you already satisfy this requirement. You have a degree, your undergraduate degree, and it can be a foreign degree or it can be a U.S. degree. So requirement number 1, you have to have an employer. Requirement number 2, you have to have a degree. Requirement number 3, the degree that you have must relate closely to the job. In other words, the job that you're going to do must require the type of degree that you have as a minimum entry-level requirement. What does that mean? What that means is that, let me give you an example. If you have an accounting degree and you are going to work for an accounting firm as an accountant, that's an excellent H-1B. It is a job that requires a degree, and it requires exactly the kind of degree that you have. So the H-1B is what they call, it's a visa that is for specialty occupations. That is, occupations that require a specialty degree in order to do them. So an accountant requires an accounting degree. A mechanical engineer requires a mechanical engineering degree. If you have a generalized degree, when I graduated from college, I had a degree in history. So it's very difficult to show that there is a job that requires a history degree as a specialty degree in order to do the job. So the advice that I have to international students is the degree, you are well advised to go into degree programs that will train you for specialty occupations after you graduate. That is, jobs that require a specialized degree in order to do the job. This requirement, the degree related to the job, is the single biggest reason for H-1B denials. That is, we submit an H-1B petition, we try to show that the degree relates to the job, and the Immigration Service says, I don't think this is a specialty occupation. I don't think that this job requires the type of degree that you have. And I can tell you that under the Trump administration, H-1B denials went up from maybe 10, 12% of H-1Bs that were H-1B petitions filed, up to well over 30% of cases were getting denied, and certainly many more than that were getting dreaded requests for evidence to prove the relationship between the job and the degree. So in our office, the exercise that I encourage employers to go through, and I encourage you to do this, is when an employer contacts me and they say, look, I want to pursue an H-1B for one of my employees, how do I go about this? What I usually say is, I need you, employer, to take a bullet point listing of the job duties. Give me 10 bullet point listing of each job duty. And then I want to go to the employee, to the student, and I want you to go through your transcript, and I want you to show me the coursework that you took that trains you to do each one of those duties. And if you can make a close correlation between the listed job duty and the coursework that you took in your degree program, if you can make a close correlation, then you will have a strong H-1B case. If you cannot make a close correlation between your coursework and the duties of the job, then my recommendation is find another job that is more related to your degree, because you will have a very difficult time getting an H-1B. So let's say that you are working using your OPT, you talk to an employer, the employer is willing to pursue the H-1B petition. The employer files the petition with the government. Right now, it's taken the government roughly 6, 7, 8 months or so to process an H-1B petition. If they agree that the job relates to your degree program, they will issue an approval notice. You can actually change your status right in the United States. You do not have to travel as long as you file the H-1B petition while you were using your OPT. You can change your status right here in the United States, uninterrupted work authorization. Once you get the approval notice, it will be approved initially for a 3-year period. You can then apply for an additional 3 years of H-1B. You can get a 3-year extension for a total of 6 years. Now, there are ways that you can actually extend the H-1B beyond that 6-year maximum. It requires that you begin the green card process, which we'll talk about here in a few minutes. But for present purposes, assume that you will initially get a 3-year approval, then you will get a 3-year extension for a total of 6 years in the United States working in H-1B status. When you get that approval notice, that only allows you to work for the employer who sponsored you for an H-1B. You cannot work for anybody else. You cannot, for example, work for your H-1B employer during the week and then moonlight as a bartender on weekends or go to work slinging lattes at Starbucks. You can only work for the employer who sponsors you for the H-1B, and you can only do the job that is described in that H-1B petition. Now, does that mean that you're stuck with that same employer for all 6 years of your H-1B? No. You can change employers. But the new employer will have to file a new H-1B for you. In other words, every time you change H-1B employers, the new employer has to file a new petition. Well, why is that? Because every time you change jobs, the Immigration Service wants to know whether the new job also requires the type of degree that you have. They approved you initially because they concluded that the job you have relates to your degree program. But when you change jobs, they want to make sure again that the job being offered to you relates to your degree program. So every time you change jobs, you have to file a new H-1B petition. But a benefit of having the H-1B and then transferring to a new employer is that you can start working for the new employer as soon as the H-1B petition is filed. You do not have to wait for an approval. So as I said, the H-1B is the most common work visa in the United States. One of the biggest hassles with the H-1B is the H-1b Quota. There is a limited quota. It is the most popular work visa in the US, but there is a very limited quota on H-1Bs. The quota year for H-1Bs runs from October 1 every year to September 30 of every single year. So the quota year that we are in right now began September 30 of 2020, and it ends, it started October 1 of 2020, and it will end September 30 of 2021. So we are a little over halfway through the quota year. So at the beginning of the quota year, October 1, 2020, the Immigration Service had available to it, starting October 1, had available 85,000 H-1Bs, and that is 85,000 new H-1Bs. That is H-1Bs for individuals who have never had H-1B before. Once you get your first H-1B, you never have to worry about the quota again. The quota only applies to individuals who are getting the H-1B for the very first time. So October 1 of every year, 85,000 new H-1Bs become available. That quota is divided into two different buckets. There is a bucket of 20,000 H-1Bs available only to individuals who have a U.S. advanced degree. That is an advanced degree from a U.S. university. So if you have an advanced degree, if you have a master's degree from UCLA, you are in the 20,000 quota. If you have a PhD from the University of Pennsylvania, you're in the 20,000 quota. If you have a master's degree from Canada, you are not in the 20,000 quota because that is not a U.S. advanced degree. To qualify for this 20,000 quota, it must be a U.S. advanced degree. Then there is a quota of 65,000 that is available for everybody else. Everybody who has a degree from anywhere qualifies in the 65,000 quota. For purposes of getting an H-1B, I get students all the time who are rabid to try to get into the 20,000 quota. My answer is, doesn't matter which quota you're in. And I'm going to explain how the quota works. You don't care whether your H-1B is from the advanced degree quota or from the regular quota. As long as you get an H-1B quota number, you are fine. I'm going to talk about how the quota works in a second. But as I said, we're about halfway through the quota year. Quota year started October 1 of 2020, and it will end September 30, 2021. Anybody have any idea what the current availability is of H-1Bs? So on October 1, 85,000 became available. And as of right now, there are zero. No H-1Bs available. And in fact, all H-1Bs were taken on the very first day that they became available, October 1 of 2020. All 85,000 were taken. And that happens every single year, that on the very first day the quota becomes available, all of them are taken because employers are permitted to pre-file to get an H-1B number. How does the pre-filing work? Well, let's look at that right now. What we have up here on the screen is a graph of the H-1b Quota Year. The quota year starts October 1, and it goes until September 30. But employers know, and now you know, that you can pre-file to get one of those H-1b quota numbers. Starting a couple years ago, the Immigration Service started a special pre-registration process to get an H-1b. And that pre-registration process runs in March of every year. And the dates of the pre-registration process will change. For this past year, the quota year that we are in right now, for the quota that opens up October 1 of 2021, employers could pre-register to get an H-1b quota number during a pre-registration period that ran from March 9 to March 25. So any employer who had an international worker using optional practical training, and they wanted to sponsor that international worker for an H-1b, had to file an H-1b pre-registration between March 9 and March 25. Doesn't matter what day you submit the pre-registration, as long as it is within that window. The pre-registration process requires the employer to submit skeletal information about the H-1b. They have to give a little information about the company, a little bit of information about the individual employee, including passport information. They submit that pre-registration to the Immigration Service. All employers all across the United States who want to get one of those 85,000 quota numbers that is released on October 1, file a pre-registration during that pre-registration period. This year, during the pre-registration period for H-1b, the Immigration Service received over 300,000 H-1b pre-registrations for the 85,000 quota. So 85,000 H-1Bs become available on October 1, but over 300,000 employers submitted a pre-registration. So what the Immigration Service does, they shut down their pre-registration period on March 25. They gather together all of the pre-registrations that were submitted, and they do a random lottery. And they will randomly select 20,000 advanced degree cases, and they will randomly select 65,000 for the regular quota. And the way they do the pre-registration or the random lottery selection gives a slight benefit to individuals who have a U.S. advanced degree. Because what the Immigration Service does first is they take all the applications that are U.S. advanced degree applicants. So they take, let's say out of that 300,000, we're not sure exactly how many were advanced degree, but let's assume it was, let's say 100,000. They take all those advanced degree cases and they set them aside. They count out 20,000. They take the remaining 80,000 that were not selected in the advanced degree lottery. They put it back into the pile, mix them all up, and then they count out 65,000. So if you have an advanced degree, you get two chances in this lottery. You get the initial advanced degree quota of 20,000. Then you get an opportunity in the additional regular quota of 65,000. They run this lottery between March 25 and April 1. As of April 1, if your case was selected in the lottery, you'll be notified by the Immigration Service that you can now proceed, or the employer can now proceed to file an H-1b petition. The employer will have 90 days to file this H-1b petition. So they're notified on April 1. They will have until June 30 to file the H-1b petition. Once the H-1b petition is filed, the Immigration Service will process it to make sure that the degree relates to the job that you've been offered. If they agree that the job and the degree are very closely related, they will approve that H-1b, and the H-1b will be effective on October 1. So let's look at two different scenarios with regard to this quota. If you have an employer that has offered you a job even before graduation, most students are going to graduate in May, so let's use a May graduation date. If you have an employer that is willing to sponsor you for H-1b even before you graduate, You can do that because to do the pre-registration, you do not yet have to have the degree that you are going to rely on for your H-1B petition. So if you are an undergrad and you do not yet have your bachelor's degree, you can pre-register in the H-1B pre-registration period as long as you will have your bachelor's degree before you have to file the H-1B petition on June 30. So if you are in your last semester of your degree program and the employer wants to file an H-1B for you before you graduate in May, they can do that as long as you will have the degree before June 30 when you file the H-1B petition. Similarly, if you are in an advanced degree program and you do not yet have your advanced degree, you can still file for an advanced degree quota number as long as you will have your advanced degree before you file the H-1B petition on June 30. So if you have an employer willing to sponsor you, they can put in a pre-registration during the pre-registration period. If your case is selected in the random lottery, the employer can then file the H-1B petition on June or before June 30. You will have your required degree by then. Immigration Service will then process your H-1B petition. So the requirement that you don't necessarily have to have the degree yet is new. It's only been implemented for the last 2 years, but it is a very important benefit for international students. But for most students, you're not going to have a job offer before you graduate. Most students are going to graduate in May. They're going to get their optional practical training and they're going to start to work using OPT. So let's say you graduate in May, you get your optional practical training, work hard, you go to work for an employer. You start to work. You get up to October 1 when the quota is released. You don't care because you didn't have a pre-registration file anyway. You're going to continue to work for that employer using your optional practical training. And what you're going to want to look at is the quota year that opens up here. That is the year after you graduate. Immigration Service will announce next March when the pre-registration period will be open. You'll want to talk to the employer about filing the pre-registration. If your case is filed for the pre-registration, you do the lottery, your case is selected by April 1, you will be notified. The employer can then file the H-1B petition after graduation on or before June 30. Immigration Service will process your H-1B. That H-1B will be effective as of October 1. So that is how the H-1B process works. But let's look at this. You graduate in May and you get your OPT. Your OPT is valid for 12 months, so it will expire here. How do you work between the expiration of your OPT and October 1? Well, the answer to that is if you file an H-1B pre-registration and the pre-registration is selected for processing of the H-1B, the employer files the H-1B before your OPT expires. Your OPT will then automatically extend until October 1 when the H-1B becomes effective. So you will have uninterrupted work authorization as long as you file the H-1B petition before your OPT work authorization expires. So that's a very important benefit for international students. Well, let's say that you are not selected in the H-1B lottery. You have an employer, the employer has filed an H-1B pre-registration, but it's not selected. Are there other options that may be available to you? Well, there are, but they are few and far between. There are organizations that are exempt from the H-1B quota. These organizations listed on the screen can file an H-1B at any time. Even if the quota has been exhausted for other employers, these employers can file H-1B anytime. So if you get a job with a university that is related to your degree program, doesn't have to be as a faculty member. If you have a business degree, you go to work for the business office of a university. Universities are exempt from the H-1B quota. Nonprofit organizations affiliated with universities, like a university-affiliated research center or a university-affiliated hospital, totally exempt from the H-1B quota. You still have to show that your degree relates to the job, but the quota doesn't matter. There's no pre-registration, there's no October 1, there's no any of that, because these employers can file anytime. Third category, nonprofit research organizations. Not all nonprofits qualify for the H-1b exemption. Only nonprofit organizations engage primarily in basic or applied research. And then there are governmental research organizations. Federal, state, or local government research organizations are exempt from the quota. But that's it. Those are the only categories of employers exempt from the H-1b quota. So if you weren't selected in the lottery for a private employer, you could go to work for one of these exempt organizations and get yourself an H-1b through them at any time. Well, let's say that you're not working for an exempt organization. Are there other visa categories that may be available? As I said at the outset of the program, there are visa categories that run from the letter A all the way down to the letter V as in Victor. Certainly there must be something out there. Well, the answer to that is it's tough. If you are from one of the countries listed at the top of this screen, Canada, Mexico, Chile, Singapore, Australia, there are options available that are very similar to the H-1b, but they never run out. Canada, Mexico, you have the TN category. Chile, Singapore, you have H-1b1, which is a special quota of H-1bs just for citizens of those countries that is never exhausted. If you are from Australia, you have an option called E3, very similar to the H-1b, but again, they're always available. So if you're from one of those 5 countries, there are excellent options that are available to you other than the H-1b. Another option that may be available to individuals is the L1 category. This is available only to individuals who are working for multinational companies. That is a company that has operations outside the United States and operations inside the United States. If you're working for a multinational company, you must first work outside the US for at least a year. Once you do that, you may be able to transfer back into the United States in L1 status to work for the company in the United States. So obviously that is a very limited option, only for individuals working for a multinational company, and you first have to work outside the US for at least a year. There is a category called the E-visa, which is for citizens of countries that have treaties of trade and commerce with the United States. If you are from a country that has a treaty of trade and commerce with the United States, you may qualify for an E-visa if you go to work for a company in the US owned by citizens of your country. So for example, Germany is one of the treaty countries. If you are a German citizen, you go to work in the United States for a company owned by citizens of Germany, you may qualify for an E-visa. It would also allow you to be an entrepreneur. So you can open up your own business if you are a citizen of a treaty country, because if you open a business, it will be owned by citizens of your country, you. Obviously, this is, again, a very limited option. It is not available to citizens of China or India, no treaties of trade or commerce. You can Google E-visa treaty countries, and you can see the list of countries and see if you are on the list of treaty countries. So let's say you don't get selected in the H-1b lottery. You are not from one of the 5 countries listed at the top of the screen. You're not working for a multinational, and you're not able to find employment with a treaty company in the United States. What options may be available to you? Well, you can always depart the United States and work outside the US. You can even work outside the US for a US-based company. You only need a US work visa if you are working in the United States of America. But what many students do if they do not get selected in the H-1b lottery, because these other options are so limited, they simply re-enroll in school and get a different degree. Not necessarily encouraging that, but that is what many international students do if they are not selected in the H-1b lottery, which again is the most common work visa. Green card is almost a separate category for its own presentation. But to get a permanent resident green card, first of all, a green card will allow you to live in the United States for the rest of your life. It allows you to work for any employer without restriction. One of the problems with getting a permanent resident green card is that there are only very limited ways to obtain one. There are basically three ways to get a permanent resident green card. First is based on family relationships. If you have a family member in the United States and that family member is either a US citizen or a permanent resident themselves, that family member may be able to sponsor you to get a green card. Not all family members qualify. It is only parents, spouses, children, and in some cases, brothers and sisters. So if you have a parent, spouse, child, or a brother or sister who is a US citizen, that individual may be able to sponsor you to get a permanent resident green card. If you have questions about family immigration, feel free to contact me. You can send me an email or give me a call. I'm happy to answer questions about that. Another way to get a green card is through the DV lottery, the diversity visa lottery. The government actually gives away 55,000 green cards every year to citizens of countries that have low levels of immigration in the United States. So if you are from a lottery, DV lottery country, that is a way that you can apply on your own to get a permanent resident green card. You can see the countries that are eligible by Googling DV, that's diversity visa lottery eligible countries. A third way, and a very common way to get a permanent resident green card in the United States, is through employment or special skills. If you have an employer in the United States and that employer is willing to sponsor you for a green card, the employer can go through a process and actually sponsor you for permanent residence. If you have a high level of skills in your background on your resume, you may actually be able to sponsor yourself for permanent residence. That is, individuals who have many presentations, publications in academic journals, significant contributions to their field. If you think you have a resume that may qualify you for one of these extraordinary or outstanding permanent resident green card categories, I encourage you to send me your CV. I'm happy to review it. I do many of these kinds of cases, and I can usually tell in about 5 minutes whether I think you're going to qualify. But as I said, green card is almost a topic for an entire presentation of its own. I wanted to give you a basic overview of how the process works. The short answer is that it takes a very long time to get a permanent resident green card, in some cases many years, and you will always have to maintain your temporary visa status in the United States while you're pursuing that permanent resident green card. So it's very important when you're graduating from US University to focus not on getting a permanent resident green card, but instead focus on the temporary options that will allow you to stay. And those temporary options are optional practical training. You must plan ahead to make sure you submit your application for your optional practical training work card within the window to apply. Once you get the card, plan ahead so that you file the H-1b pre-registration during the proper period. If your H-1b petition is then selected and approved, then you can start thinking about permanent resident green card. And with that, I will open it up to questions.
Thank you so much, Mark. Goodness, I think we could probably have a day-long session with just you and certainly answering the multitude of questions as well. So thank you so much for just the thorough overview and being able to cover so much ground. Kind of combing through the Q&A questions, there's a lot in a lot of different categories. So I will try and pop around and ask you some questions that hit some of the different categories. So the first question I have is, are there resources for students to find out what jobs people have been hired for with their majors? Really kind of, I think a big question is knowing that these students have to find careers that line up well with their majors. How do they determine which jobs sort of best match? And kind of related, one question also was, if their major is different from their minor, could they get a job related to their minor? Does that qualify, or it has to be related to their major?
The major course of study is the one that is going to qualify you for H-1b. A minor is not going to qualify. And again, there are resources out there of organizations that have sponsored H-1b in the past, and many students will try to focus on employers who have filed H-1b in the past. But the bottom line is this. the vast majority of H-1b petitions are filed by organizations that have never filed an H-1b before. And in my practice, I've been doing this for over 25 years, and in my office, we've certainly processed over 25,000 H-1b petitions. Most of the clients that we represent are small to mid-size employers, and many of them have never done an H-1b ever before. One of the materials that I made available to the group and that will be made available to you, I'll show you this using my high-tech audio-visual aid, is this thing that I call my easy guide to hiring foreign graduates. It's a one-page piece of paper. I encourage students always, if they are talking to an employer about the immigration process, take this piece of paper with you. It talks about optional practical training. It talks about the H-1b. It has my contact information on it. Employers can feel free to contact me. I don't charge for these kinds of consults. And I've had hundreds and hundreds of employers over the years who have never done an H-1b ever before. They've called me up on the phone, and usually in about 5 minutes, I can walk them through the process, and they're very comfortable doing an H-1b after I finish talking with them. In terms of how do you determine whether the job is one that is going to require the type of degree you have, we've filed many creative H-1bs over the years, and trying to creatively show how the job duties relate to the coursework that you took. Some of it is going to be your creativity. You need to be able to explain how the courses you took relate to the duties of the job that you are going to perform. Most employers are not going to want to offer you a job if the duties are totally unrelated to the degree that you have. They want a degree that's related to the job that they're offering. So it's up to you to be able to make a narrative of how those courses relate to the duties of the position.
And I just wanted to clarify, I know you had mentioned H-1b in that response, but does that also apply for OPT?
Yeah, OPT is a little, the standard for how related your degree has to be to the job that you are going to perform is a little looser standard using optional practical training. When you apply for H-1b, you're applying to the Immigration Service, and they hate the H-1b program, so it has to be a very close correlation. When you're getting optional practical training, you are proceeding through your international student office. You need to make a sensible relation between the duties of the job and the degree that you have, but it's not going to be quite as rigorously reviewed as the Immigration Service reviews it.
Thank you. And then kind of jumping over to, I know we didn't really speak about CPT, but there have been some questions about, can I do an internship? And then what about, on-campus versus off-campus part-time employment? Well, I'm sorry, I should say just on-campus part-time employment, and then can I do an internship? And if you could just briefly talk about CPT.
Yeah, the very important thing about CPT is that that is going to be run very closely through your international office at your university. So CPT questions, I always refer students to go to their international student office and discuss issues regarding CPT. CPT is only available to individuals who are in a degree program that has a work component that is part of the degree program. So you will need to work with the international student office to determine whether the degree program that you are in has a work component. If you are in a degree program that has a work component, many business degrees have a work component requiring you to go work and get practical experience working off campus with businesses. You'll need to work with your international student office to determine whether your degree program has that work component. If it does, CPT can be authorized by your university. You do not have to go through the Immigration Service. But it's important to understand that when you are an international student, you are not allowed to work in the United States unless you work in the very limited ways that the law allows international students to work. One way is optional practical training. Another way is curricular practical training if your degree program has a work component. You're also allowed to work on campus in any on-campus job. But with those exceptions, you're not supposed to work in the United States. So if you are working off campus and you're not using CPT and you're not using OPT, you are going to have a problem. So it's very important for you to run any work opportunity that you have by your international student office to make sure that you are not running afoul of immigration laws by accepting that employment.
Thank you. For H-1B, do individuals have to commit 6 years to the company who files their H-1B? And can they also travel outside the US during that time that they have the H-1B?
Yeah, when the employer initially files an H-1B, the employer will get a 3-year H-1B approval. You do not have to stay with that same employer the entire time. You can leave and go to a new employer anytime you want to. The new employer must first file a new H-1B for you. So, for example, let's say you graduate, you go to work for employer A. Employer A will file an H-1B for a 3-year period of time. Let's say after 1 year, you're sick of employer A and you want to move to employer B. You can do that. Employer B will file an H-1B petition on your behalf. That employer will also ask for 3 years. If it is approved, you will have used 1 year of H-1B with employer A, 3 years of H-1B with employer B. That's 4 years total. You'll only have 2 years left of your 6 years of eligibility. So in other words, you can move employers all you want. Each employer has to file a new H-1B, but you will only get a total of 6 years, no matter how many employers you jump around to in the meantime.
Thank you. There are so many questions, and I know we can't get through all of them, but I just want to encourage everybody who's Zooming in with us today, take a screenshot if you'd like of these resources. We will make this recording available to all of you. There have been questions as well, Mark. Can they get access to this PowerPoint presentation?
Oh yeah, absolutely. I can forward that. I think Karen may already have a copy of it and she can distribute that around. I'm happy to stick around for a few more minutes if it'll help. But otherwise, if students didn't get their question answered, feel free to send it to me and I will make sure we get some kind of response to them.
Thank you so much. I'm going to turn it back over to our host, Karen.
Thank you so much, Mark, for a very informative presentation. And thank you, Stacy, for managing the Q&A for us today. I know we have a lot more questions from students, so like Mark said, please feel free to reach out to him. And we will also be making the easy guide that Mark mentioned. We'll be making that available to those who registered. So check your email in the next week or so. You should be receiving that along with the link to access the video for this session. So again, thank you to our audience for joining us. We hope you enjoyed this presentation. And I just have a quick announcement before we jump off today. As part of this UC Career Conference for international students, we do have 2 additional webinars coming up. In the next session, we have a panel discussion among recruiters and international alumni who will be sharing their experiences and insights in the job search. And finally, we'll have a webinar about ways to boost your job search with a few practices in mindfulness. So we hope you'll join us for these next sessions. Thank you again and take care. This concludes our webinar.